All right, let's move on then. Presentation on responsible party and liabilities of oil spills. And that's with Linda Swiss and Breck Tostevin.
Good morning. I'm Linda Swiss, and for the new board members, welcome to our board. And just to introduce myself, I'm the contingency plan project manager in the Anchorage office. And today we have a presentation by attorney Breck Tostevin. So I'm going to give you a little background on Breck. He's an experienced environmental law attorney, and his practice, besides civil litigation, his practice also includes oil spill contingency plan compliance, contaminated sites, and environmental insurance coverage. And the firm that Breck is currently associated with is Nielsen Koch, based in Seattle. He's been with them since 2017. Prior to that, Breck was a senior assistant attorney general in the Alaska Attorney General's office. So from October of 89 until July of 17, about 28 years, Breck represented the Alaska Department of Environmental Conservation in a variety of environmental matters, including oil spills, contaminated site cleanups, and compliance with oil discharge prevention and contingency plans. And again, I think I mentioned this yesterday, that's ODPCP or C plans. A tidbit of information about Breck is he actually had a college class with former President Barack Obama, and he went to law school with Vice President Kamala Harris. So I thought those were kind of interesting tidbits about Breck. As far as his presentation, the responsible party issue kind of came up about a year ago. I believe it was Steve Lewis had some questions about it. And especially with the transition between from BP to Hillcorp with taking over the BP's assets, who is actually the responsible party for each of the shippers in the TAPS trade, and whether the responsible party covered both operational and financial responsibilities. So we wanted to better understand these questions and the association between the tanker owners, the tanker operators, and the contingency plan holders. So we reached out to Breck, and this is what his presentation is going to be on. It's sort of who pays for oil spills. He's going to cover a little bit about cleanup responsibilities, financial responsibilities, liabilities, and then this presentation will be followed up within the next few weeks, hopefully, with two documents. One is going to be a fact sheet of who's on the hook for what if there's a spill from a TAPS trade tanker in the Prince William Sound captain of the port zone. So it's a long title, but it's really sort of a cheat sheet and a quick reference of who's on the hook for paying for the spill. And then also another document, a white paper called Responsible Party 101. And hopefully those two documents will help summarize. This is a pretty complicated understanding of responsible party. So hopefully that simplifies it, especially for new board members that have not been used to like delving into these details. And with that, I'll turn it over to Breck.
Good morning. Can people hear me okay?
Got you fine, thank
Great.
you.
Okay, well, thank you. Well, I kind of call this the meaning of life talk. It might be simple, and some people who have a lot of experience with it, it may be obvious, but it could be good but there are certain nuances to all this that are important. And for people who aren't as experienced with it, I'm hoping you might get the big picture perspective on some of these issues. So I want to make an initial distinction between cleanup responsibilities, which is the duty to actually go and do a cleanup, versus liability for oil spill costs or damages, and that a court might impose upon someone after a spill, or that a person would in a settlement pay. So I'm gonna make that's an important distinction. I want to first talk about cleanup responsibilities. Under Alaska law, any person who causes or permits a discharge of oil has a duty to go out and clean it up. That removal includes restoration of natural resources. And then the holder of an approved oil discharge prevention and contingency plan has a duty to implement that plan with the quality and quantity of resources that are set out in the plan and that they're required to implement the provisions of the plan. I call them contingency plans or C plans. They're very important documents because they both impose a legal duty to implement it, but also has the details about how one goes about using that equipment. Alyeska, as the common operating agent for TAPs, has a legal duty under state law to respond to tankers, TAP tanker spills in Prince William Sound. That's a unique provision. Under federal law, the owner and operator of a facility or vessel is a responsible party, has a duty to respond to the spill. And the holder of a federal response plan, a vessel response plan is the federal equivalent, and it provides the holder of that plan has an obligation to respond with the, they've contracted with an oil spill response organization, so that oil spill response organization has to respond. And then also on the Trans-Alaska Pipeline Authorization Act, which was passed in the 70s, there's a duty of the holders of the permittees under the Trans-Alaska Authorization Act, both for the pipeline and for the terminal. They have an obligation to remove pollution from the facilities or that occur in the right of way or in vicinity of the right of way. So as far as the state contingency plan, who is the state contingency plan holder? Well, it's generally the tanker operator. It could be the owner if the owner is providing the crew and operating the vessel, in which case they could be the holder, but generally it's the operator. Alaska has a unique provision that allows a person with primary operational control to be the contingency plan holder. So that has allowed people, entities who aren't the operator to spot charter tankers. And what they do is they have a contract, a primary operational control agreement, whereby they have control, that the C plan holder has control of the tanker for operations in Alaska waters, and that the vessel has to follow the prevention and response procedures in the C plan. And those are important components of that. Under federal law, the operator of the vessel is the federal plan holder of the vessel response plan. So the state plan holder and the federal vessel response plan holder can be different companies. However, all TAPS trade tankers use Alyeska as their primary response action contractor, so that's a consistent concept. The next key piece of the system is the financial responsibility assurances. Under Alaska law, tankers and terminals cannot operate unless they establish and maintain financial responsibility, and that's for both response costs and damages. And there are certain amounts that they have to establish, and that includes for crude oil tankers, it's based on the barrel storage capacity of the tanker. It's not how much oil the tanker is actually carrying, but it's actually the capacity of the entire tanker. So it's set by statute and regulation at 561.30 per incident per barrel. So for example, I've given you some figures here of what the different shipping companies' largest tanker in the fleet produces financial responsibility of. So for example, Alaska Tanker Company is 729 million. For crude oil terminals like the Valdez Marine Terminal, the required financial responsibility amount is 93.55 million. So this required amount is adjusted periodically for inflation. So effective June 24th of this year, DEC has adopted regulations which are increasing the amounts that increased for the terminal, for example, to 97.75 million, and the per barrel storage capacity for crude oil tankers goes up to 586.50 per barrel. So the next set of distinction is liable persons. What are people liable for under for spills? Under Alaska law, we have strict liability, joint and several, which is important. Strict liability means liability without fault. That if you're the owner or the operator and there's a spill from your vessel, you are liable. It doesn't matter the degree whether you were negligent or not. The owner and operator of the facility is a liable person. The owner of the cargo at the time of the release, this is a unique Alaska provision, is also liable. It's joint liability, which means that if there are multiple responsible parties or liable parties, one liable party is responsible for all the damages caused by all the parties. And if one party can't pay, the other parties are on the hook. Parties can allocate liability among themselves, but that's in a separate step of a piece of litigation. The responsible parties as to the public or as to injured persons cannot allocate liability. So in a separate contribution act, the responsible parties can allocate responsibility among themselves based on fault, but not as to the public or injured persons. Under federal law, under the Oil Pollution Act of 1990 and the Federal Water Pollution Control Act, the owner and operator of a vessel or a facility are strictly liable. But for vessels, the federal law sets liability limits, and that's based on the gross tonnage of the vessel. An important point, though, however, is those liability limits can be broken if there's gross negligence, willful misconduct, or, this is important, a violation of a federal safety, construction, or operating regulation in conjunction with a spill incident. In those cases, there is no liability limit, and the liability is without a cap. So the federal caps, for example, for a tank vessel is $2,300 per gross ton. So for example, for the largest tanker in Prince William Sound, that comes out to 196 million. So it's less than the state financial responsibility amounts. For other vessels, it's 1,200 per gross ton, just to give you an example. And that's for both removal costs and damages. The Valdez Marine Terminal is a little different in that its liability scheme is based on the Trans-Alaska Pipeline Authorization Act, which sets a $350 million cap, and that's strict several liability. That's based on percentage ownership of TAPs. Now, that's for damages to public and private persons. However, it's uncapped if there was negligence involved. So if there was negligence involved in the spill, the $350 million cap doesn't apply. Now there's a specific provision for unlimited liability for removal costs, which I mentioned before. So if there's been a spill and there's removal costs incurred by the federal government, there is not limited liability. The Federal Water Pollution Control Act has a separate liabilities provision. It's a $50 million cap for federal removal costs and also federal state natural resource restoration costs. But that cap can be broken if there's willful negligence or willful misconduct within privity means connection with and knowledge of the owner. In that case, there's full liability. So that's the scheme for the terminal. Now under state law, Alaska law, there are not liability limits. However, as a practical matter, Alaska's proof of financial responsibility laws, as I talked about earlier, have dollar amounts. So as the proverb goes, you can't squeeze blood out of a stone or blood out of a turnip if the entity doesn't have the resources. there could be limited recovery. And the other point I would make is financial responsibility only applies to contingency plan covered facilities and vessels. So for example, a fuel tanker truck isn't going to have financial responsibility. A fishing vessel doesn't have financial responsibility. So I want to briefly talk about liability for what? Well, generally speaking, the liability is for removal costs and damages. A removal cost can be incurred by the United States, a state, a tribe, or any person who's acting in compliance with the National Contingency Plan. The National Contingency Plan is simply the set of federal regulations that set out the spill response system in the United States. And damages are defined in Oil Pollution Act of 1990. There's some broad categories of damages: property damage, loss of subsistence use, economic damages, both for profits and earning capacity. So if a fishing industry, because of a fishery being shut down, could recover profits and earning capacity, or a cannery, for example. There are also government claims, lost government revenue, so if lost fisheries taxes is an example. Also, they can a recovery for increased costs of public services. So if a government has to provide more fire and police protection, other services as a result of a spill, those increased costs can be recovered. The next big category under Open 90 is natural resource damages. It provides for recovery for injury, destruction, loss of use of natural resources. It includes both damages and also the cost of assessing the damages. And so natural resource damage assessment costs can be quite substantial in figuring out, what was harmed and how to, and then the second step is how to go about restoring the environment. So these are recoverable by a federal trustee or a state trustee, and those are persons and government entities which are designated by the president or the governor. These provisions were imposed by Open 90, but before Open 90 was the Exxon Valdez oil spill, and you might recall that there was a consent decree, federal consent decree, with the federal government and the state government and Exxon, whereby Exxon paid some $950 million for natural resource damage assessment, and that created the trustee council of the federal and state trustees, which then administered those funds for the restoration efforts. So this provision of Open 90 kind of statute puts that in statute, and the reason there's a trustee relationship is because there, for some resources, there's going to be both a federal and state trustee. I mean, there are injured migratory birds. There's a federal trustee as well as a state trustee, for example. So, I wanted to talk about the state hazardous liability statute, hazardous substance liability, which is mentioned before, is strict liability, liability without fault. It's liability for damages, and under state law, damages are more broadly defined. It includes things like personal injury that wouldn't have been covered under the OPA provisions, and then also recovery for costs of response by a state, municipality, or a village. But private persons can also recover response costs as well, as I'll mention, and also the increased costs of government services similar to Open 90. Who can use 822? Well, the state, municipalities, and private persons. The Alaska Supreme Court recognized that private persons can recover damages under the act, and that those damages can include cleanup costs. So I've been talking about statutory liabilities. There are also statutory oil spill penalties, civil assessments. There are also common law and maritime law liabilities for oil spills. I'm sure you remember in the Exxon Valdez spill, the private plaintiffs were awarded punitive damages against Exxon under the general maritime law, and that went through a was delayed for many years as a result of litigation in the federal district court, the Ninth Circuit, and then eventually the U.S. Supreme Court in 2008 reduced the punitive damages award to $500 million based on the federal admiralty law. So I just wanted to give that background as well. So the Spill Liability Trust Fund is a source of funds both for the federal agencies and the state agencies in the event of a spill. And so it's a backup if there's a failure of the plan holder responsible party to respond. And it's also a source of funds both in a couple ways for natural resource trustees who can pay for natural resource assessments and restoration as well. But it's also an important source for claimants, for individuals and corporations and government entities who can submit claims that aren't being compensated by the responsible party. Those claims have to be presented to the responsible party, but if they're not satisfied, they can be presented to the fund, who then adjudicates those claims. So it's a source of compensation for injured persons if the federal liability limits are exceeded in a spill. But the fund is limited to $1 billion per incident, excuse me, and $500 million for natural resource damages. I understand that the council has supported legislation that I guess Senator Sullivan has introduced that would increase those liability limits to something like $2 billion per incident and $1 million for natural resource damages. But that hasn't been enacted yet. So now I want to talk about the state fund. The State Oil and Hazardous Substance Release Prevention and Response Fund, or 470 fund. It has two accounts. It's a smaller account. It has $50 million balance or cap to it. The prevention account funds ongoing state response to spills. The prevention account is the state's ongoing programs. The response account is a funding for the state's response to oil and hazardous substance spills that are declared an emergency, or there's an imminent substantial threat, then the commissioner can use the fund. But unlike the federal fund, it doesn't pay private claims. So it's funded by the 4 cent a barrel crude oil surcharge, which funds the ongoing programs and the prevention account, and then the 1 cent a barrel surcharge for the response account. There's also a 0.95 cent per gallon refined fuel surcharge, which also helps fund the prevention account. And then also if there's been recoveries, cost recoveries from responsible parties from either fund, that those monies go back to the respective funds. So the Alaska response account is below its $50 million cap because it's been used for spills. So it's being replenished over time by the 1 cent per barrel, but since production is down, crude oil production is down, that is filling slowly. Over time, there'll also be recoveries from the responsible parties that will go back into that fund. So that's the state fund. And now, so I want to talk about two examples from the various tanker fleets to kind of try to put this all together and give you some examples of how it all works. So example for the Alaska Tanker Company, they operate the Alaska Explorer, which is one of the larger size tankers. That tanker is owned by Kiska Island LLC, but it's operated by the Alaska Tanker Company LLC. And both those entities are going to be responsible parties under federal law and liable parties under Alaska law. Then ATC transports Hillcorp Alaska's crude oil. So they would also be a liable party under Alaska law in case of an incident. ATC is the holder of the federal vessel response plan, and also is the holder of the state sea plan. And that they have ATC has a federal certificate of financial responsibility and also a state certificate from the state. The amount of the state FR for the tanker is 729 million, and Alyeska is its primary response action contractor in Osro. My second example is more complicated. It's Hillcorp North Slope LLC spot charters of foreign tankers. Hillcorp holds the state contingency plan that was previously held by BP Oil Shipping, that they used to spot charter tankers to transport crude to Asia. So the Jones Act doesn't apply to shipping oil to other countries, so you don't have to use an American flag vessel. So I'm using the Zenith Spirit as an example, which they have used a couple times for spot charters. It's owned by Zenith Spirit LLC, and it's operated by TK Marine Singapore. Both are responsible parties under federal law and liable parties under Alaska law. Hillcorp is the owner of the crude oil. It's also going to be a liable party under Alaska law. So TK Shipping Limited holds the federal response plan. I haven't seen the TK Shipping federal response plan. It wasn't submitted as part of the state plan amendment, so I do not know if the Alaska plan is an annex to the TK Shipping response plan. That's usually how these spot charters are done, is that the Hillcorp plan is an Alaska annex to the federal VERP, and then that makes the operator who holds the federal VERP comply with the response and prevention measures of the Alaska plan, which is an important issue. The state contractual terms didn't talk about primary operational control, and it didn't address compliance with the state sea plans prevention and response measures. So I think those are important things that need to be remedied. Let's see, the Hillcorp, as I mentioned, the Hillcorp North Slope LLC as the state sea plan holder, and that Alyeska is Hillcorp North Slope LLC's primary response action contractor. And they had a statement of contractual terms with Alyeska for response in state waters. It's not clear to me whether Hillcorp North Slope LLC is a party to the Gulf of Alaska agreement, which provides response in federal waters in the Gulf or not. So that's a point that needs to be clarified. TK Marine Singapore has a federal certificate of financial responsibility for the tanker, and Hillcorp North Slope LLC has a certificate of financial responsibility from the state. The required amount of state FR for the tanker is essentially $591 million. I haven't seen the underlying insurance and other financial responsibility for the state financial responsibility. So I do not know whether the financial responsibility meets has the endorsements and the details of the financial responsibility. Me bringing up that point reminds me that I didn't say something about financial responsibility that I wanted to say. And that is that financial responsibility is met through kind of different mechanisms. It can be through self-insurance or guarantees. If you use self-insurance, you have to prove ability to pay and working capitalization in different amounts, which are set out in the regulation. You can also meet it through letters of credit. But if you're using insurance, there's very important provisions Alaska has about an endorsement to the insurance, which provides that you can bring a direct action against the insurer in Alaska court, and that the insurer is actually subject to suit in Alaska court to pay out the actual amount of the financial responsibility. So those are important parts of the state law. Sometimes people will have more insurance than is required by the FR amounts, and they might belong to protection indemnity clubs, which provide additional coverage. But those additional coverages may or may not meet the requirements that are in state law, which I call the gold standard. So anyway, so that is part and parcel of my try to attempt to define the meaning of life, and I'd be happy to answer any questions that folks have.
Thank you. It's quite a in-depth presentation. Steve Lewis.
Breck, thank you. Your last two slides are kind of what I had in mind when I raised this question some time back. But my question for you is, and thank you for that, that was very, very helpful and a complete answer to what I was kind of driving at. You said that there's some things that still need to be resolved and potentially some things that need to be changed. And I'm not sure if you meant resolved in just us getting a little more information or resolved in terms of some sort of regulatory modification. So could you expand on that statement just a tiny bit, please?
Sure, and I think my answer to you is both. I think for the from the financial responsibility, I know that the council has asked for additional documents, and I think when we get the additional documents, we'll be able to see what kind of insurance is in place and where the endorsements are there. So on the issue of the and then I think if we can actually see the federal vessel response plans, that may resolve some of the issues. I think that what I call the primary operational control agreement, there's something that's submitted called a statement of contractual terms as part of the C plan. I think there might simply be needed a different statement of contractual terms in terms of an operational control agreement. I think what was provided is the wrong form, the wrong statement of contractual terms. So I think that needs to be changed. So that's more of a regulatory fix, or the next spot charter should address that issue by having the correct statement.
Okay.
I don't know if that's clear and answers your question.
That's helpful. The bottom line of that is we still got a little bit of work to do at poking at this.
Right.
Okay, thank you very much.
Robert Beadle.
Thank you, Robert. Breck, very good presentation, informative. A few quick questions. So I think you answered one of them, the money put up for the amount of storage they're capable of. That's just an insurance policy. It's not a cash or a bond.
It can be a bond. That's one. A guarantee is one way of meeting it. There's different ways that you can prove financial responsibility, but yes, that's it can be insurance, it can be self-insurance, can be a letter of credit, a bond, but for each of those tools, there's a set of requirements you have to fulfill.
Okay, and then where's the boundary? Who takes over between state and federal? Where's that boundary? Does Fed supersede state, or how does that? When do those rules?
Well, an Oil Pollution Act of 1990 made clear that states could impose additional liabilities for tanker oil spills, for example, and that we could require, or states can require, additional financial responsibility. So Alaska has unlimited liability that's authorized by OPA 90. Alaska has higher FR amounts, and that's allowed by OPA 90.
But it applies anywhere. It applies. I was trying to get it if it was in state waters or federal waters, or where's the breakdown? Who can be? Whose rules do we use when?
Oh,
is that a
state jurisdiction, generally speaking, is 3 miles right off. But if a spill can affect state waters, then the state can then the state implements its incident command system and You know, if there's a threatened spill to state waters, if that's what you mean.
Right, then when does feds come in and take over, or say
Yeah.
my rules apply or supersede yours?
Well, you were asking a very complicated question on the meaning of life. But
Okay, I didn't mean it. I thought
no,
there
it's
might be
okay,
a-
and I'll give you a, you know, are you talking about in terms of an incident command system and an actual spill and who?
No, you gave several examples of different how the feds handle it and how the state handles the situation. Okay,
Mhm.
and then so I'm wondering, without them stepping on each other's toes, is there a you know, navigable waters in a certain place is under state, we follow their rules, or after a certain point we follow federal, or are they both jump in at the same time if there's a spill? Or
Well, if we're talking about liability in state waters, both the federal and the state rules apply, so they live harmoniously together. If you're out, you know, federal waters go out to you know 200 miles is the exclusive economic zone. So if you're outside of state waters and in the federal waters, then the federal rules apply.
but so in the middle of the sound, if there was a spill, the feds and the state would be there.
Yeah, both. Absolutely.
Okay.
Yeah. And there's a cooperative scheme, and there's the whole incident command system where everyone just works together, and you know.
Okay. And just really quick, it says Hillcorp, Alyeska is Hillcorp's primary responder. So, but Alyeska is 300,000 barrels in 72 hours. So if they're responding to a spill and they're still, you know, they were shipping oil shortly afterwards out of in 89, but aren't they supposed to be able to respond to an event if another tanker or something, heaven forbid, have an incident? If they're the primary responders and they're taking care of it, I mean, are they not meeting their obligation to ship oil if they're busy on a spill and can't respond to a new one?
Mhm.
I mean, as a condition of shipping oil, is that?
Well,
What I'm trying to get at is, how could Alyeska be the primary responder after 72 hours and still meet their obligations?
Well, they have I guess there's two. I heard two parts of your questions. I heard two questions. One is the piece of Alyeska having resources for the 300, and then what you call the out of region, the maximum oil discharge under state law. And so they have resources to address both of those, and they also have contracts to bring resources both, you know, from the sound and from within Alaska and outside to meet the bigger spill amount. You know, they have agreements with the other co-ops and to bring in equipment. The question of if there's a spill, do you keep shipping oil and opening the terminal? That's a whole nother question and a process that I've actually seen spill drills where they exercise that question, and what additional resources have to be brought in so they can resume normal operations. So as far as state law, the way the statute is written, all operators can rely on the same set of equipment to meet the response planning standards. So it's not like, you know, all facilities have to have their own unique set of equipment. If they can rely on the different oil spill co-ops and to meet their standards.
Yeah, okay. But I'm thinking there's a forest fire and you've thrown your assets at that, and another forest fire pops up and your assets are busy on the first fire, and the second one doesn't get attention.
Yeah. Well, I think they call this the cascading thing, where if you've used resources to do a spill, the national response system is supposed to cascade resources in from around the country to fill the gaps. So,
Okay, thanks.
yeah.
I'm still a believer in Santa Claus, and so, thank you.
Luke Hassenbach.
Yeah, thanks, Robert. And yeah, thanks for the presentation. And I may have missed it during your while you were talking, but I saw all the amounts that are supposed to be guaranteed to be available. Is there a timeline, like when they are available? Are they supposed to be immediately, or when do they hit the clock on the total amount is available for those funds when an incident happens?
Well, you're supposed to have access to those, to that financial responsibility. I guess the practical answer, I don't know, but I mean, some of those assets, I guess it depends on the mechanism. I mean, the financial guarantors are supposed to step up.
Okay, yeah, I was just curious. I'm sure there's assurances. I'm thinking as a ship agent where you have to start ordering all these services, and a lot of vendors and stuff want guarantee of payment and expect stuff to be expedited relatively quick for such big ticket items. I was just there's a certain mechanism that says they have to have it available within 30 days or a billing cycle or something like that.
I think if you're a response contractor, most people's contracts address, you know, timeliness of payments, and that's kind of what the C-plan requirement is. Requires contracted resources so that there isn't uncertainty about what you know, whether people are going to get paid on time.
Okay, thank you.
Jim Herbert.
Breck, a complex subject and my head is spinning. I could not do what you do, but you've given me insight. My question for you is, I understand that the state laws, statutes are stricter in many ways than the federal. What kind of attempts have been made by the legislature to roll back some of these things? Is that something we as an organization need to be mindful of? Thanks.
Well, I am not aware of any legislative efforts to roll things back right now, but I think, yes, you should be mindful of that. I mean, I think the state's oil spill laws are something that should be maintained, obviously. Something that was built up over a long period of time, and a lot of blood, sweat, and tears went into them.
Anything further? Joe Lally.
Thanks, Robert. I was just going to try and answer Luke's question about when the funding or the resources would need to be available, and according to the vessel response plan and probably the state financial responsibility. I mean, that those contracts and whatever mechanisms they have in place to provide that should be available immediately to respond adequately to an oil spill. And if they're not, that's when the feds are able to, if they needed to, if the resources weren't provided in a timely manner, or they thought that the response was not adequate, then that's when the oil spill liability trust fund would be looked at as a mechanism to provide it. But the first line of defense and the way the system's built is the spiller pays, the responsible party pays. So that's how that would work.
Thanks, Joe.
Thank you.
Robert, I would just like to wrap up this presentation by just letting folks know that as Breck mentioned, there's some documentation that we're waiting on. We've done, we did a public records request for the financial information on Hillcorp North Slope, and Breck did a public record request on some of the other shippers. So we did get the first response, and it showed that we had more questions and more information that we needed. So we're just waiting on receiving that from DEC. Just so folks know, we're still working it.
Thanks, Linda.
Thank you. And thank you to Breck.
So Breck, I just have maybe one more question, and it's maybe you made a little reference to the Gulf of Alaska agreement. And is that an agreement with just the Osro with Alyeska and shippers, or is the state involved in that? And how would we find out more information about that? Any idea there?
Actually, Robert, Breck looked into the Gulf of Alaska agreement for us back about 6 months ago. I can gladly send that out. I don't
Okay.
think Breck's probably prepared to delve into it because it's also complicated.
Yeah, well, I think we've had enough complicated information for 1 hour. So thanks so much, Breck. I think that it's a real eye opener, and it points out to another fact that financial responsibility and C plans are not easy. And if SPAR and DEC are trying to write C plans that address financial responsibility, it's good to have people in positions that make decisions that can understand what this is all about. So thanks so much for your presentation.